Is leave time a reasonable accommodation under the ADA? Have you ever wondered if leave time can be a reasonable accommodation under the Americans with Disabilities Act? This is an important question for both employees and employers. Let's break it down. Under the Americans with Disabilities Act, leave time can indeed be considered a reasonable accommodation for employees with disabilities. However, there are specific conditions that must be met. A reasonable accommodation is any change to a job or work environment that helps a qualified individual with a disability perform their essential job functions without causing undue hardship to the employer. Leave time is often granted to employees to recover from surgery, manage chronic health conditions, treat mental health issues, or recover from injuries. This also applies to pregnancy-related conditions when covered by related laws. It is crucial for employers to engage in an interactive process with the employee to determine the appropriate amount of leave. This leave should be equitable compared to what is granted to other employees in similar situations. There is no set duration for leave under the Americans with Disabilities Act. Instead, it is determined on a case-by-case basis. However, indefinite leave or excessive time off is generally not considered reasonable. This is because it can impose an undue hardship on the employer. The leave granted should be for a defined period, and the employee should have a clear ability to return to work after the leave ends. Leave can be either paid or unpaid, depending on the company policy and applicable state laws. Regardless of whether the leave is paid, the employee's job and benefits must be protected during this time. After the leave concludes, the employee should be allowed to return to their position or an equivalent one. Employers must balance accommodating the employee's disability with the operational needs of their business. If an employee cannot perform essential job functions even with leave or other accommodations, or if the leave requested is indefinite with no clear return date, the accommodation may not be deemed reasonable. For those in administrative careers, understanding that leave can be a reasonable accommodation under the Americans with Disabilities Act is essential for managing employee relations and ensuring compliance. It is vital for employers to document the interactive process carefully, assess each request individually, and apply leave policies consistently. This helps avoid discrimination claims and maintains a fair workplace while meeting legal obligations under the Americans with Disabilities Act.